number 2025 TR 1215. Quentin Hyde appears apparently on his own Zoom. Jaron Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. Mr. Hyde, court has an information before it which alleges in count one a charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count two, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions?
Out of the gate, Quinn refuses to enter a plea. Most people at this stage just say guilty or not guilty and let the process move forward, but he's already trying to cross-examine the judge about paperwork. You can almost feel the judge thinking, here we go again.
Good afternoon. I do not intend to plead.
Why is that, Mr. Hyde?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Hyde. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
I see nothing openly defective about the charging document.
Okay,
let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Hyde. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have...
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not...
This is a first real standoff. Quinn demands a probable cause because he hears that he's got the system cornered, but the judge isn't having it. He just reminds him that this is a misdemeanor, not a felony, so he's not entitled to one. It's a textbook moment of someone trying to play lawyer without understanding the rules.
I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that correct?
I will be presenting myself, that is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one?
I do comprehend this, thank you.
But you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting myself.
Very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentin Hyde under it, pending further.
Now here's the kicker. The judge asks if he wants a lawyer, and Quentin proudly says, "I'll be presenting myself." That phrase alone tells you what lane he's in. People who go down this path usually end up making their cases messier. Self-representation almost never works out, but he's convinced he's got the magic word.
That I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Hyde, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for that.
I do believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you.
And now he's questioning whether the court even has jurisdiction. A classic sovereign citizen move. He talks about inconsistencies in the documents like that somehow makes the charges disappear. You can hear the judge's patience wearing thin, but instead of snapping, the judge just keeps the train moving.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea. Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regard.
Is where it gets dramatic. Quinn refuses to accept a not guilty plea, says it's being entered under threat and arrest, and then tries to dismiss the whole case on the spot. Honestly, it feels more like a performance than a legal defense. The judge, though, doesn't bite. He just notes the plea and moves on.
May I also ask what judge?
Just a minute, I'm going to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quentin Height at this time?
Not on this particular matter, Your Honor, although in per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's order, if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good.
So let's go ahead and cite for Mr. Height, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance?
The state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9 o'clock a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3 o'clock, Mr. Height. I think that concludes our business on the case at this time.
One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said. You mean in this case that was before the court today?
Correct.
This judge is hearing the case. Okay.
Thank you for clarifying.
And if there's nothing further, the Quentin Height matter will be in recess at this time, and we'll
Then, in a plot twist, the prosecutor drops the bomb that Quentin has another pending case. Suddenly, all this courtroom theater looks even worse because this isn't a one-time situation for him. Even as the judge calmly explains his upcoming dates, Quentin is still nitpicking about which judge will preside. It's almost like he's more interested in controlling the stage than actually defending himself.